My name is Genaro Cortez. I'm a San Antonio criminal defense attorney, and today I want to give you an overview of federal sentencing. In particular, I want to tell you what to expect after you've either pled guilty to a crime in federal court or after a jury's found you guilty of a crime in federal court. This will include talking about the Probation Department interview, the pre-sentence report, how to object to the report, and most important of all, how to use the 3553A factors to ask a federal judge to give you the lowest sentence possible. So let's get started. Now, after a person pleads guilty to a federal crime or is found guilty by a jury, the next thing that happens is the case is assigned to a federal probation officer. And that probation officer will schedule an interview with the defendant and his or her lawyer. That interview can happen either the same day if you pled guilty, or it can be scheduled a day or a few days or weeks after that date. It'll depend on the division or district you're in, and it'll also depend on whether you're in custody or out on bond. But during that interview, the probation officer will ask you questions about yourself. She'll basically take your biography and history, where you were born, where you went to school, your job, the jobs you do, your family, your children, and she'll ask you a few other questions about that, or he. And they will also ask you to sign a release of information so they can get your medical records, your financial records. This is all standard part of the Probation Department interview. One of the things that will also happen at the Probation Department interview is something called AOR, Acceptance of Responsibility. And during that acceptance of responsibility portion of the interview, the probation officer will ask you, what do you want to tell the judge about what happened in this case? If you've pled guilty, then what you need to say, or what you need to tell the probation officer is, you need to accept responsibility for what you did. Show remorse. That on July 9th, 2022, I agreed to do whatever it is you did. And then after that, you say, I accept responsibility for what I've done, and I apologize to the court and to the community for the harm I've caused. Something along those lines. There's not like an exact quote or verbatim statement you need to say, but it needs to show that you acknowledge that what you did was wrong and that you're remorseful about it. If you do that, then you'll qualify for acceptance of responsibility, and that should lower your guideline range between 2 to 3 levels. Now, this may not apply if you've gone to trial and you've lost. If you went to trial and you lost, you may not want to make a statement. The reason is you're not going to get acceptance of responsibility points, and it may jam you up when you appeal your case. So if that happens, definitely talk to your lawyer ahead of time about what you should say as far as the acceptance of responsibility portion of the interview goes. Now, after the interview is done, at least where I practice in San Antonio and Del Rio, it takes a couple of months for that report, for the probation officer to prepare a pre-sentence report. But once the probation officer prepares a report, they'll send a copy to both the government and the defense attorney. When the defense lawyer gets a copy of the report, then he or she will schedule an interview with a client to review that report. That's a huge part of the case. You need to review that report carefully with your lawyer, because that report will tell you, it'll contain the biography and history you told the probation officer, and it'll also contain the facts of the offense or whatever it is you're accused of doing or pled guilty to. That information comes from the government, and it's not always accurate, and it can lead to a higher guideline range. So you need to read it carefully with your defense attorney to make sure there's no mistakes. If there is a mistake, then you need to your lawyer needs to file an objection with the probation department. So those are the things to look out for. Now, the PSR is also going to contain something called the guideline range. Now, a guideline range is how much time, an estimate of how much time you're going to get. In federal court, judges, prosecutors, and defense lawyers use something called the sentencing table. The table has 2 axes. The vertical axis is numbered between 1 and 43, and that's because every federal crime has a number assigned to it between 1 and 43. And the higher the offense level, the more serious the crime, the higher the offense level. On the horizontal axis, there is a criminal history category that ranges from 1 to 6. If you've never been in trouble before, and this is the first time you've ever been arrested, you're going to be in criminal history category 1. However, if you're a career offender or you've had a lot of convictions, then you're likely to be farther to the right on criminal history category 6. That's the farthest you go out. Now, where those two access points meet, that's your guideline range. That's an estimate of how much jail time you're going to get. That doesn't mean that's what you will get. That's just a baseline of where you're going to be at. And the judge can go higher, or the judge can go lower, or the judge can say, you know what, the guideline range is just right. So that's how the sentencing table works. But the key point, or the key takeaway of the sentencing table is this: the higher your offense level, the higher the jail time you're going to be looking at. Also, the higher your criminal history category, the higher your jail time. So those are the two factors that can increase your jail term, and you will see that information in the PSR. So review that information carefully. Now, the next step is after you get the PSR report, the next step is the sentencing date. That's when you go to court and the federal judge decides what to do. So let's talk about the sentencing hearing now. Now, the first thing that judge is going to ask you is, did you get a chance to review the PSR with your defense attorney? It should be yes. If you have not reviewed it with the PSR with your lawyer, you need to tell the judge and then ask for more time so you can do that. After that, the judge is going to ask, is there any objections to the PSR? If you have objections, that's when you raise them. So you file them first with the probation department, and then you raise them with the judge at that point. And then the judge will walk through your objections. He'll make sure that the sentencing guidelines are correctly calculated. He'll check your offense level and your criminal history category. And if he believes you're right, then he'll accept the guideline range that's in the PSR. If he thinks the guidelines are wrong, then he'll make adjustments to them. So you want to be careful to make sure that you don't miss any mistakes or errors in the PSR. Now, after that, the federal judge will give both sides a chance to speak, and they can ask for whatever sentence they think is best. Defense lawyers will ask for the lowest sentence possible, and prosecutors tend to ask, for a guideline range or above the guideline range. But the key is, after the judge gives everybody a chance to speak, what he or she will do is consider the 3553A factors. This is a federal law, and it requires a judge to balance those factors to see if the guideline range is just right, if it's too high, or if it's too low. So I want to talk about those factors, what they are. I'll give you the legal definition, and I'll show you how you can use them to ask the judge for the lowest sentence possible. Now, the 3553A factors, there's about 7 of those factors. And the first one is the nature and circumstances of the offense and the history and characteristics of the defendant. The next one is the need for the sentence imposed to reflect the seriousness of the crime, promote respect for the law, and to provide a just punishment. It also includes it also makes sure that there's an adequate deterrence to the criminal conduct, and it protects the public from future crimes from the defendant. It also provides the defendant with needed training, either educational training, medical care, or if he needs rehabilitation for drug use, it'll also include those types of things the judge will consider. The rest of the factors include the kinds of sentences available, for people that committed that specific type of crime, policy statements that are contained in the guidelines and in the statutes, also a need to avoid unwarranted sentencing disparities between defendants with similar records who did the same crime, and finally, the need to provide restitution to any of the victims of the offense. Now, that's the legal definition, and it's plain in the background, so I showed you what the law is. Let me show you how it works and how you can use it. One of the biggest things that we look at are the nature and circumstances of the offense and the history and characteristics of the defendant. That's the first factor, and that's huge, and here's why. That policy, that factor allows the defense attorney to humanize the client. In other words, on paper, you're a criminal, but that factor lets the defense attorney put context to you, to your background, and to your biography, how you got to this point in your life, and why you're not likely to reoffend. And you can use that, you can do this in several ways. Now, the probation officer, when he or she interviews you, will ask you to sign waivers so they can get your medical records, you can get your military records, and those sort of things. And you can help the probation officer to help you. Okay, the probation officer is not for you, he or she is not against you. Their job is just to get the information, as much information as possible and as accurate as possible to the judge, so the judge can make a decision. So if you can help the probation officer by providing them, if you're in the military, your medical records, if you got a Purple Star or Purple Heart or other kinds of medals for valor, then you're going to want to provide those documents to the probation officer. Likewise, if you're on Social Security disability, then you're going to want to go to the Social Security website, get your records, and give them official records of your disability. If you have medical records or medical history, like diagnosis such as schizophrenia, bipolar, or if you've gone to rehab and successfully completed it, you're going to want to get those types of documents to the probation officer. And from there, when you go to sentencing, then your defense attorney can include that information in your sentencing memorandum, and you can also tell the judge, hey, Your Honor, Mr. Fulano de Tal or whoever, they did something wrong, and they should be punished. But that punishment should also reflect all the good things they've done in their life. They served in the military. They volunteered in the community. They've been responsible at work. And this is an aberration. In other words, this is not who they are. On top of that, you can also show that you're not a violent person if that's the case. The key is it's got to be accurate information, and it needs to be objective information. And you can walk through those 35538 factors to find the ones that best fit your case. Not all of them will always apply in your case, but at least one or two will apply, and you can use them to chip away at the guideline range. So to recap, what happens is the probation department prepares a PSR. That PSR contains a guideline range based on the sentencing guidelines. That'll give you a rough idea of how much jail time you're looking at. After that, you go to court, and you can tell the judge if you agree with the guidelines or you don't. If you don't, then you object to the guidelines, and then the judge will make a decision on whether the guideline range is correct. But after that, that's when you can use the 35538 factors to push down the guidelines, to bring them down. And then if you have a good case, if you have good facts, and if you have the documents to support it, a lot of judges will move on those and move in your direction. But you got to be careful. There's some warnings. Some judges may go the other way. If it's a bad fact, for example, a bad case, for example, if people died in the crime, if it was an alien smuggling case and you rolled over and people died, or if it was a drug trafficking offense and people were shot, or people died from the drugs you were selling. If there's extreme facts like that, it may be hard to move down the guidelines. In fact, it may push the judge up on the guidelines, but you can still use this to contain the sentence, to keep a bad situation from getting worse. So this is one option. This is a pretty big option. The 35538 factors give you a chance to push back on what happened in court. It allows you to become a human again, and it gives you control, or at least a certain amount of control, where you can work with your attorney to get these records to the probation department, so you can ask for the lowest sentence possible. Now, nobody wants to be in federal court for sentencing. That's a nightmare scenario for just about everybody. But if you're there, then the next step is, how do I get out of this? How do I minimize the damage? And the 35538 factors give you that option and that opportunity. There's no magic wand and there's no promises. These are just the steps and the laws you can use to ask for it. In the end, it'll be up to the judge to make that decision, but you got to help them out, and you got to put your case in the best possible position for the judge to move in your direction. Now, I hope this information is helpful. If this video helps you, or if you like the information, click the like button below and subscribe to our channel. Also, if you have any questions about or suggestions for future topics, shoot me an email at info@cortesdefense.com. I enjoy talking to people about this stuff. I'm kind of a geek about this, and so just shoot me an email and I'll respond when I get your email as soon as I'm able to. Thank you for listening, and don't forget to click the like link below. Thank you.